Hello everyone, so welcome back to the English Law channel. So I'm now coming on to easements and profits à prendre, as in profits to take. So that's from the French apprendre. So an easement is a right that one landowner has over the right of someone else. A right of way is the one we see all the time, although that's sometimes just for the general public. An easements are something which are best explicated through examples. If two neighbours have agreed that since one house has no garden, the owner with a house without a garden can use the next door house's garden, then that right would be an easement. And the leading case in this is Ray Ellenborough Park from the Second World War. So there are some definitions that you need to understand. They're negative easements, they're positive easements. But anyway, let's look at positive easements first of all. For an easement, you have to have a dominant tenement and a servient tenement. The dominant tenement is the piece of land which gives its owner rights over the servient tenement, and the servient tenement is the piece of land whose owner has to put up with the rights of the dominant tenement owner. And they don't necessarily have to be touching each other, though they usually were. So profits à prendre are the right to take something, to pick fruit, for example, to go fishing, to hunt animals, to take truffles, things like that. And this is taking fruit to sell. Now, usually, if you're on land, you can pick wild fruit, like berries or something, to eat yourself, but you can't if you're selling it. Doing a commercial scale is not allowed. Generally speaking, you can go onto someone else's land in this country. Anyway, trespass is a civil wrong. It's people almost never take action against it. It can be a criminal wrong if it's a huge number of people in an organised way, seeking to cause damage or disruption. There are certain places where, under the Serious Organised Crime Act, it's a crime to go without authorisation. For instance, royal palaces, military bases. Okay. So legal easements can be created by law, and these last as long as the fee simple in possession or term of years absolute. So an equitable easement, this is another type of easement, and it includes those ones which are created informally. The easement can be held for a set period of time, or could be fee simple in possession or term of years. So an easement gives a benefit to one piece of land, the dominant tenement, and a burden to the other, the servient tenement. The burden and the benefit apply to the land itself, and they're not personal, they're not for that individual. The next title holder would get the rights as well. So it goes with the land, not with the person. When that person sells that piece of land, he no longer has that right. The new owner has the right. So it's a proprietary interest. So it passes new owners, with the rules of conveyancing and registration. So the new owners of the land will often find that they're bound by third-party rights if they buy the servient tenement. So there are different rights involved here in easements, and proprietary rights can pass, and they disrupt the servient owner's ability to use the land to enjoy it as he sees fit. So law is trying not to add to the list of easements. Easements mustn't be too imprecise. But easements are needed sometimes to use the land effectively, or to make it worthwhile in a business sense. So the law changes from time to time. So it's said that the list of easements is closed, that you can't have new kinds of easements. And there was a decision about this, Regency Villas, Title Limited, and Diamonds Resorts Europe Limited, 2018. So it's hard to say what easements are, because there are so many different kinds, and it's been a little bit adaptable. So let's look at some of the defining criteria of an easement and compare and contrast with other rights. So the Court of Appeal looked at Ray Ellenborough Park 1956, and the Supreme Court has subsequently said, yeah, that's right, especially in that Regency Villas Title Limited case. Anyway, so Ray Ellenborough Park, there were people who owned houses that surrounded a public park in the UK, and in the Second World War, that park was taken over by the government. The house owners, not public park, it was a park just for the people who lived on the square. The government took it over, and people got compensation by statute. The only compensation they could get was an easement. So the owners persuaded the Court of Appeal that their right to use the park was an easement. And so there were 4 factors that I'll go into in some depth about this. So the rules from Ray Ellenborough Park they seek to balance the rights, the dominant tenement, the servant tenement. They have to have a certain elasticity to them, and they're regarded almost as though they're statutory. Okay, so here are the criteria. So there must be a dominant and servant tenement, as I already said, but that's different to a profit, because a profit can exist in gross, as in be unrelated to the ownership of land. An easement can only exist tied to land ownership. It must be appurtenant to a dominant tenement, and remember, if you sell it on, then the new owner gets it as per the LPA 1925. So London and Blenheim Estates Limited against Ladbroke Real Retail Parks 1994 is a case about that. The creation of easements for land is not identified, is impossible. So it can only exist linked to land. But remember, that's different from profits. So this is very clear, must be linked to land. And there are many cases on this. Lord Justice Peter Gibson in London and Blenheim Estates Limited, as I said. The Law Commission said it's possible to allow easements to exist if we allowed easements to exist in gross, it would lead to a proliferation of adverse interest in land, unlimited by the needs of dominant land. So the Law Commission warned against it. But some people say this doesn't make much sense, because this requirement would stop the creation of easements, which are good for the economy, good for the dominant land. Okay, so if there's land burdened with the easement, that's the tenement. There's the servient tenement. Sorry, the easement, remember, is a proprietary right, and it impacts the servient tenement, and it could be enforced against new owners of the servient tenement. So the second criterion is the easement must be serving the dominant tenement. The servient tenement serves the dominant one, which dominates the servient one. So it can't, remember, it's not for an individual, it's only through land. So it will make your ability to enjoy land greater. Hill and Tuppett, 1863, is a case about this. This was a right to put pleasure boats in a canal for profit, and it was found not to be an easement, it was just for personal gain. That's different from Moody and Steggles, 1879, where the right to put an advert on neighbouring land was regarded as an easement. If the land is used as a public house, as a drinking establishment, that's not just benefiting the current owner, but that's to do with the nature of the land itself. P&S Platt Limited against Crouch, 2003. In that case, it was about moorings on the Soviet land, which was so a hotel could get people to come by boat, and Regency, their recreation facilities on the burdened land, and that was good for people who had the timeshare business on the dominant land. It was an advantage for them. So anyway, you also need to see the need for accommodation, and it must be applicable to the case you're looking at. So Ray Ellenborough Park, there was a claim about a house which had a garden, and using the garden for recreation, the communal garden, and so there's been a lot of debate about this one. People said it's like recognising a personal recreational land's rights for those who occupy land. In the end, the Court of Appeal said the accommodation requirement was fulfilled through the use of land at the house, what they got from enjoying this recreation, and it wasn't through any incidental increase in the value of the land. So the next step is the Supreme Court and Regency saying that the recreation, including swimming, ability to play sports and so on, is part of modern life, and that's a benefit. And there's no ban on recreational and sporting easements. You know, if you're allowed to use a tennis court next door or a swimming pool, what's crucial here is the fact-specific context of each particular case, that the rights claimed over the Soviet land accommodate the dominant land. So this poses a number of questions about any limitations there might be. So remember, it's the dominant tenement, the serving tenant must have some sort of connection, even if they're not actually adjacent, as per Pugh and Savage. They can't be hundreds of miles away. So number 3, the dominant serving tenants must be owned or occupied by different people. It can't be the same person who has both pieces of land. You can't have an easement over your own land. So there's a thing called a quasi-easement in Wheeldon and Burrows. So you have to have diversity of ownership at the time that someone applies for the easement. So number 4, the easement must be something which could be a grant. So an easement must start out as a grant, an express grant, an implied grant, a presumed grant, and there have to be certain conditions which are satisfied. First of all, there must be a capable grantor and grantee, like an adult of sound mind. Second of all, the right must be clear. If it's very imprecise, then that won't work. So the nature and the extent of the right have to be spelt out, so we can determine what they are. Cases of free access of air are about this. Bryant and Lefevre, 1879. Cable and Bryant, 1908. Okay, so here's an acronym for the Ray Ellenborough Park criteria. It's DADS. D, dominant and servient tenement. A, accommodate the land. D, diversity of ownership. And S could be the subject matter of a grant. So there are more things to consider. It's a right, there are various rights which can exist as easements, and we can't have different kinds, new types of right. So anyway, they're positive easements, and obviously things have changed over time, which is easements can be a bit different from before, but they have to have some sort of link to easements which have already existed. Positive easements are those which allow the dominant tenement to do something on the servient land. Negative easements are those saying that you cannot do something on the servient land. You can't build this, you can't block my light, you can't dig that. You can't operate a business on it, something of that nature. Easements of light. Hunter and Canary Wharf, 1997. The House of Lords said negative easements are anomalous, and this category of easements, again, is closed and you can't add to it. So exercising this right must not require any action on behalf of the servient owner. So any right which obliges someone to do something is not an easement. Judge Pelling QC in William Old International Limited and RA in 2009 said, an easement cannot impose an obligation on a servient owner. The servient's only obligation is to refrain from doing anything that impedes the enjoyment of the easement by the dominant owner. Remember, the easement is a right which is exercisable, and you don't need permission to do it. Once you've got it, you can always do it. It can't be contingent upon permission being granted by the servient landowner. As it was said in Green against Ashco Horticulturist Limited, 1996, a purported grant of right-of-way for such periods as the servient owner may permit one to use it would not confer any legal right at all. Close quotation. So it can't be on the say-so of someone. Once you've got that right, they can't take it away. You can use it whenever you want. Remember, the easement must not confer a right so extensive that gives exclusive possession of the servient tenement. If we're trying to figure out this is an easement or it leads to exclusive possession, well, we think if the right over the person's land is virtually the same as an estate in land. So it's crucial to realise that an easement is a right over the servient land for a certain purpose. It's not to do anything you want. It mustn't be so extensive that you effectively deprive the servient owners of any rights. So the courts find this a bit tricky about car parking. There have been a lot of cases about the right to park a car. So some people say this is too much, depends on the nature of the land, how large it is. The Court of Appeal and Batchelor and Marlowe, 2001, looked at this, and Lord Scott opined over to dicta in the House of Lords decision on a Scottish case in Moncrief and Jameson, 2007. So there are different judicial attitudes to this, trying to find an equilibrium between the various rights. In Batchelor, it was said that no reasonable use tests were seen as binding in English law. Verdi and Chana, 2008, Kettle and Bloomfold Limited, 2012, De La Quona against Big Apple Marketing Limited, 2017. The wide interpretation and of application of these seems to be in keeping with what Lord Scott said, but there's nothing vital about the parking cases. That's just a contemporary example of some of the thorny issues that the courts have to deal with when they're trying to figure out whether an easement should be allowed or not. Wright and McAdam, 1949, was about storing things in another's land. Miller and Emger Products was about someone who wanted to be able to avail himself of a lavatory in a servient tenement, and that was found to be an easement. So anyway, this was exclusive possession of the lavatory, I suppose, but it was for rather a brief time, I hope, unless he hadn't been eating fruit. So let's look about how easements can be created. So an easement can exist at law and in equity. The difference between them is crucial, since there are different ways to create them, and the difference is vital in determining whether the easement runs with the land, as in when you transfer the land on the dominant tenement, the servient tenement, is it going to be enforceable against new people? So legal easements, to exist at law, an easement must be an interest equivalent to an estate in fee simple absolute in possession, or a term of years absolute. That's as per section 1.2a of the LPA 1925, and it can be created expressly or impliedly. Now, so on to equitable easements. So equitable easements are held for a certain period of time, either fee simple absolute in possession, or a term of years to be equitable as per the LPA 1925. An easement can also be equitable. It was not created by one of the methods for setting up an easement. So an easement for life or an easement can be created informally, cannot exist at law, but they could take effect in equity. Equitable easements can be made by a written contract, which equity seems as specifically enforceable as per the Law of Property Miscellaneous Provisions Act. Walsh and Lonsdale, 1882, is a case about that. They can be created through proprietary estoppel. So the land is registered, then it could be protected by notice on the land register. In unregistered land, an equitable easement can be registered as a Class D3 land charge under the LCA 1972. Easements usually become extant through a reservation, for instance, if the seller of the land reserves the right of the way of the land sold, or through a grant, for instance, where the vendor of the land grants the buyer a right of way over the retained land. So reservation and grant could be express or they could be implied. There's express creation. An expressly created easement is legal or equitable, and that is according to whether the sort of document that sets it up. So an express legal easement must fulfill a number of conditions. Duration, according to the LPA 1925, can be created by deed, section 52 of the LPA, and that's further to the Law of Property Miscellaneous Provisions Act. If it's created after October 2003, it must have substantive registration as per section 27 of the LRA 2002. So an express equitable easement must fulfill a number of conditions. It must be created in consonance with section 53(1)(a) of the LPA 1925, or be created by a person with an equitable estate only, or because of the legal formalities set out here and before have failed, this failure is still specifically enforceable contract because that is good enough for section 2 of the Law of Property Miscellaneous Provisions Act 1989. So there's also express reservation, where the owner of the dominant tenement decides to reserve a right for himself when he sells or leases some of the land. The reservation is a re-grant, so the buyer is regarded as having granted the easement to the vendor. So that means that if there's any lack of clarity in the definition of the easement, this cannot be dispelled by looking at the situation. The grant is construed against the grantor, not against the buyer. In St Edmundsbury and Ipswich Diocesan Board of Finance against Clark, number 2, 1975, was a case like that. There's also express grant, and that's it's just exactly what it says. The owner of the servient tenement chooses to grant a right over land to the owner of the dominant tenement. Okay, so that's enough for the moment. Toodaloo.